We're ready whenever you are.
Thank you, Ron. Good morning, members of the court. I'm Michael Barbara. I represent the petitioner, ADS Building Contractors, in the trial court, and here, and Mr. Angelo Szynski is the manager and representative. He's present. Your Honor, please court. We're here, of course, to review Judge Huey's order determining the amount of a lien transfer bond.
Well, if I could, sir, I'll just get right to the point. You're here on a writ of certiorari,
Yes, sir.
correct?
Yes, sir.
Because you didn't like the amount that he arrived at
That's
in
correct.
setting this bond.
Right.
Okay, so it's difficult for me to see that there's a departure from the essential requirements of the law when you're only quibbling as to the amount of the bond. So he applied the correct law, but he just didn't apply it the way you wanted it applied.
No, sir, he did not apply the correct law. It's our position that he did depart from the essential requirements. The statute 713-24 is mandatory that the amount of the attorney's fees and costs must be as basically incurred.
Wait a second, it's only mandatory. Mandatory language comes after the trial court determines what is sufficient, correct?
No, sir.
I can read the statute for you if you want. That's what it says. It's the trial court's job to determine what amount is sufficient, correct?
Yes, sir.
And then once it does that, it's mandatory to increase it by that amount, correct?
Yes, sir.
Okay, so to determine what is sufficient, isn't there an element of discretion involved?
Yes, there is a
Okay,
small
so
element
let
of
me ask you
discretion.
this question too, because in your motion to increase the security to $100,000, you included, and I quote, "You anticipate additional fees and costs in excess of $20,000 to complete trial."
Right.
But there's no express provision in 713.24 for modification of security to cover future
That's correct.
anticipated costs. So you would admit that that part of your motion is legally insufficient, wouldn't you?
Yes, sir. But we made
And how
no
about the other
application.
fees that you also conceded before the judge in the hearing that you even conceded weren't related, such as defending the counterclaim, the HUD inspector, the expert McCary working on new damage calculation, defending the claim, for punitive damages, time spent with expert Testa, time spent for concrete slab inspection that you admitted needed to be repaired. So, and you told the court those weren't related too. So we have a hearing where the judge is applying the correct law. He's inquired about certain fees and your opponent says, well, Judge, they're not related to enforcing lien. Judge Huey then looks at these and then you concede that some of them are not related, which I appreciate that.
I did not
So isn't it
concede.
up to Judge Huey to determine that?
Pardon?
Isn't it up to Judge Huey to determine the amount to increase it by?
Yes, sir. But if you look at his ruling, the way he ruled and what he ruled, his findings are absolutely error and not what we are dealing with. If you look, his ruling stated, first of all, that he said he acted as if we had asked for compensation for what was due in the consolidated case in the county court and the complaint. We did not. He said that we asked for compensation that was due in the 7 counts of the second amended counterclaim. We did not. And that's why I would like to be able to present to this court.
So it sounds like you're concerned about errors of fact.
It's in his ruling, when he made his ruling.
Well,
It's the
you disagree
entirety
with
of
the
the ruling.
ruling because you don't like the facts that he found. You disagree with the facts. How is that a departure from the essential requirements of the law?
Because, Your Honor.
A judge can, if a judge applies the correct law incorrectly, it's not a departure from the essential requirements of the law. Do you understand that?
It is, when he said that the matters were not intertwined, that is a legal statement, a legal finding. And the matters that are intertwined and that are here do justify a significant increase in the law. And if I could just give 5 or 10 minutes of the history of where we go, because this hearing took place 3.5 years after the filing of the complaint in this case. And the judge in his ruling basically ignored the first 3 years of the litigation.
Well, but your opponent didn't move for arbitration. The court ordered you that, correct?
I'm sorry?
Your opponent didn't move for arbitration, correct?
He tried in the beginning.
Well, but the court denied that, but then the court ultimately, sua sponte, ordered you to arbitration, correct?
No, he waived arbitration by filing the counterclaim.
Okay, so he didn't force you to arbitration, the court did.
Sorry, no, there was no enforced arbitration at all. As soon as they filed a counterclaim, that waives the right to arbitration.
Okay, but you arbitrated the claim.
No, we did a non-binding arbitration, and that's what I wanted to get to, just briefly. We proceeded to trial as normal on a mechanics lien foreclosure with a 2-count counterclaim for breach of contract and fraudulent lien, which is then you're litigating the validity of the lien. We get ready to go to trial. 3 days before the trial, the opponent, Mr. Amity, filed a motion to continue. The judge did not grant that motion to continue. Instead, he ordered non-binding arbitration, which was after, that was in February of 2019. It was supposed to be a 30-day non-binding arbitration. We'd already mediated to an impasse. We had an arbitrator appointed. We started it. He had to have surgery. It was during COVID. It ended up, it was supposed to take 30 days. It took 5 months. It cost $17,000. It was a 2-day arbitration. And then when we finished that, the ruling of the non-binding arbitration was not acceptable. And we requested, both sides requested a de novo, trial de novo.
Well, but your opposing counsel was saying that the amount of your lien, the 21,000 plus, which he offered $23,400 or $24,300 for, was never in dispute.
Oh, no, that's absolutely not true, Judge. And this is what I'd like to
Well,
go
but
through.
when you were offered that amount, it's in the record because you didn't object to his response. When you were offered that amount, the $24,300, you rejected it and asked for some $3,000 more for lost profits or something.
No. There was, and this is where it's important. During the initial portions of the litigation, we reached an attorney's agreement as to we would accept $22,000 and change for complete satisfaction and release of all parties in the agreement. He sent back a red line or blue line agreement, which is in the file, which said he's X'd out all that and said that the amount will be paid only if the lender agreed to it and only in accordance with the agreement and only if we surrendered the building permit to the homeowner and only if we agreed to be continually responsible for any defects and provided a contractor's warranty. So there was no settlement. And those terms would respectfully to the court, it would be, I mean, I don't have enough malpractice insurance if I would have accepted that kind of agreement to turn to the client and say, okay, release your lien, but you don't know how much you're going to get paid. There's no guarantee of payment. And you're maybe responsible for who knows how much money for any claim defect. So there was no agreement, Judge, despite what was said. There was months of offers, counter offers, and it was not only the money, it was the terms and conditions. And if it wasn't a complete release, we couldn't do it. Then we continued with the litigation. And so then we went into the litigation. Normal expenses would have been, attorney's fees wouldn't have been too bad. And then the non-binding arbitration. And then when you look at what happened after that, is what this is all part of this, and it is intertwined. Judge Holder found out that they had sued me and the defendant, ADS, in county court for violation of fair trade, the Fair Debt Collection Practices Act and Florida Consumer Credit Act, and he consolidated the cases because it was a central core of facts. And then, as soon as that happened, counsel filed a motion to recuse me, saying I was going to be a witness. And then Judge Holder recused himself. Then Judge Huey got the case, and he filed another motion to allow the addition of this counterclaim with 7 counts when there was only 2 before. Judge Huey allowed it. And so this was the first time that the defenses that Judge Huey talked about in his ruling actually occurred. So for the first 3 years, and what we were doing trying to enforce this mechanics lien and the attorney's fees that were done there and the non-binding arbitration, all of those fees are basically, and because there was no claim for any of the fees in the county court case. We've never made a claim for that, and we never attempted to make a claim for that. How much time about that, Judge?
You're at 11 minutes.
Okay. So that was never an issue, that we never made a claim for that. Judge Huey said, as a matter of finding a fact, that we did make a claim for that, and that was not intertwined. We never claimed it, and so his rationale, his whole ruling is wrong. And that has to be an error of law.
Well,
basically,
but unfortunately, under the case law, it is not. Okay, and that's kind of why I asked you the very first question out of the box. To be a departure from the essential requirements of the law, as I said, as long as he, used the correct law, even if he applied the law incorrectly, it's not a departure of the essential requirements of the law.
All he did
And
was,
because you don't like his rationale or his ultimate number or his ultimate decision, none of that's a departure from the essential requirements of the law. It's a pretty high standard in cert.
I got that, but he made an order basically increasing the bond. And in so doing, he looked at our paid $67,000 worth of attorney's fees and $4,000 in costs. And so we have $4,000 in costs. He only increased the attorney's fees by $5,000, despite the 3 years of litigation. So that, as you read with in the cases, in this court's case in the Bayview Construction Corporation versus Jomar, you acknowledge that the certiorari relief for reducing or increasing the bond amount is, in fact, that the contractor is going to suffer material injury for which there's no adequate remedy on appeal, then certiorari jurisdiction applies.
So you have no adequate remedy on appeal?
Not finally. Yeah, no, not for the loose, because when the bond is placed, the $40,000 bond is placed, we have a $200,000 piece of property. Put a $40,000 bond on it, it's now gone in terms of the only collateral that the the contractor has is the bond. He can no longer look to that deep collateral that's in that would have been the value of the
Well,
case.
certainly it is a desirable remedy, but you have other remedies.
Not on that, because what it is that as the court, and then there was if I can decide if they can please the court.
And were you referring to the Bayview Jomar Properties case?
Yes, I
Okay,
believe so.
and in that case, the court found that the trial court did not depart from the essential requirements of the law, right? And that's what we're talking about here, that this case doesn't meet that.
The Bayview case?
Yes.
No, I just, in the Bayview case, the one that we dealt with, that was the 2012 case from this court. And that is, the transfer bond there did not, because it's found that it did cause material harm to the contractor, but could not be remedied on appeal, and entitled the contractor certiorari relief for the interest and attorney's fees which continue to accrue. But they didn't sufficiently protect it since that there was no guarantee that the property owner would be able to pay the difference. And
You're at
that's
15 minutes, just so you know.
okay. But
It's your time. You can use it any way you want.
okay, I just one more statement. This is under the Taylor Industries construction case, which is cited in the briefs, and the Copen Barton case says the purpose of the bond increase provision of the mechanics lien transfer statute is to preserve the lienor's right to adequate security for amounts due him under the mechanics lien law. And the 1998 amendment is, as just said Justice Sleep, the lienor has a right to adequate security for the amounts due to him. And under the amendment, that the relief is compulsory upon adequate showing that the bond is insufficient. We have made that adequate showing. And that adequate showing was verified, time and billing records showing and deleting what was not intertwined, it was not the same, still came up with $67,000 and $4,000 in costs. And an increase of only $5,000 from the statutory amount is woefully insufficient. And we believe, and I believe, that the argument meets the criteria for certiorari jurisdiction. And I yield whatever time I have reserved.
You'll have 3 minutes when you return.
May it please the court. Even Amity for the appellee. Your honors, you nailed it on the head. Judge Huey followed the law. He held an evidentiary hearing. It was within his discretion to determine the increase. On February 14th, 2018, ADS responded and said, we agree with the lien amount that you need to pay us this for this extra work that was not part of the contract. The contract specifically says that if it's not within the scope of work, it's not part of the contract. Now, if you look at the transcript, counsel during the evidentiary hearing, before I start, please excuse me, there's something unusual about this case that I noticed during when I was preparing yesterday. Judge Huey said, I can waive experts and determine what's reasonable. So as you're reading the transcript, both parties stipulated to that. Neither one of us included that in the briefs. That's why you're not hearing from experts on what's reasonable. So Judge Huey just wanted to hear arguments of the times and for him to determine what was reasonable. That's why it was only 2 hours. Considering the amount of time, it made more sense for the parties to argue what was reasonable. And the argument was primarily on, was it reasonable to incur $67,000 to recover $24,000? So let me get back to the point that I was making. In the transcript, counsel states on page 39 through 40, in the beginning, Mr. Steinman sent a letter terminating the contract. In that letter, he put an offer to settle and he gave a chart of what he agreed was the amount he thought was the amount due. We responded in that offer to settle and saying, we agreed that this is the very beginning, first day, day one. We agree with Mr. Dowd, who was the inspector. He came up with a value. We agreed to the value. And then I said, we also think we're entitled to the ceiling that you got that wasn't on the plans and the fans that you got that were not on the plans. And that you
So the lien amount was never really contested.
The lien amount
So
was
the
conceded on the
point is, any dollar in attorney's fees after that is not being incurred to enforce a lien that was agreed to.
even in the settlement agreement, my client was willing to pay the full amount. That's, in fact, before I even got involved, this is the most egregious collection case I've seen around. because
Homeowners cases have a tendency to.
yes, had
Get out of here.
ADS, I'm sorry, had ADS accepted payment for the lien amount on February 8th, 2018, or at any time before the lawsuit was filed, this case would be about a $5,000 claim about a patio ceiling, a fan, and any lost profits as a result of my client's.
So that was the sole dispute, the fans and the patio ceiling, right?
Judge Huey heard the evidence. What the appellant is trying to do now is re-argue the facts and let you reweigh the evidence. and
Counsel,
make your own
let me ask you this, So in the transcript, the court asks the parties, says something to the effect that the amount in the dispute, and asks, was there a stipulation to the amount to that fact? And what we're talking about here. And the court says, would there be a stipulation that ADS is owed the $22,000? To which the owner's counsel responds, our expert report says so.
Yes.
Is that a sufficient stipulation?
Well, the evidence, the pretrial communication shows that we are always willing to pay the lien amount. If you look at the expert report,
I guess
It starts with
the
that
only
amount.
reason I ask is the court's asking, is there a stipulation? And the response back isn't yes or no, it's, well, the expert report says so. So I'm trying to interpret that.
okay, the argument that I presented at House Counsel to trial level was, we never disputed the amount. There was work that was not completed.
Well, your answer in defenses to the complaint admitted the lien amount is correct?
I have to check on that. I
I
don't
mean,
know.
as I read it, you admitted the lien amount is it.
Yes, but I don't know. I have to look at the answer. I don't want to mislead you or I don't know if I considered to the amount, but the lien amount, since day one, before my client even retained counsel, was undisputed. That my client said, and the contract, this was a HUD contract that required the homeowner, the homeowner gets a HUD loan. That HUD loan pays for the renovation of the house. But the way it's paid is a HUD inspector has to look at the work completed, has to approve it. And then my client signs off on it and then the contractor gets paid. So if you look at the settlement terms, we said, fine, you can get the amount, the lien amount. Once the HUD inspector completes, we'll sign off on it. The lien amount was never disputed. What the appellant requested was a full release, which is something that wouldn't have been granted at trial if the lien amount was established. My client would have had to pay the lien amount plus waive any defective work, any that could be cured at a later date. The offer also demanded that my client pay out of pocket the settlement amount instead of following the terms of the contract. So it was, and the Tri-Take case, Your Honor, and this, Your Honors, in this case, is very persuasive. The court relied on the Tri-Take factors in determining what would be a reasonable increase on the lien amount. And the court in Tri-Take said a trial court has the discretion to make a determination that neither party has prevailed in a significant issue in litigation after a thorough examination of all factors. And these are the factors the Supreme Court said. The issues litigated, the amount of claim of lien versus the amount recovered on the lien, the existence of set-offs, counterclaims by the borrower, and the amount offered by either party to resolve the issue prior to the litigation. Now, if the court dismissed all claims, the trial court tomorrow dismissed all claims and awarded ADS the amount it seeks in the complaint for the lien amount, the $21,700 something. It is less than what was offered on February 8th, 2018, when my client terminated the contract. So the issue before the trial court was whether it was reasonable to incur $67,000 to recover the amount that my client offered on day one. This whole litigation was about amounts that were not part of the lien foreclosure action. The patio ceiling, the lost profits. In fact, it's evident from the record that those amounts were not included in the claim of lien. The claim of lien reflects an amount about the same or less than what my client offered on day one. So is it reasonable to protect the liener's interest in the lien by running up fees to collect other amounts? That was the issue before the trial court, and the trial court looked at the evidence and made a determination, as your honors concluded, there was no departure from the essential requirements of law. This is not the place or the time to re-argue the facts of this case. That day will come at a later date at the conclusion of this case. For that reason, your honor, the court should deny the record.
Thank you.
Unless you have any questions, I'm sorry, I didn't ask.
Thank you. You have 3 minutes, sir.
Thank you. First, I'd like to refer the courts to Regency Homes, Dade versus Pagoda, which is cited in the briefs. In that case, the contractor recovered the full amount of the lien and prevailed as a counterclaim. And the defendant, homeowner, claimed that the lien was fraudulent and with a similar affirmative defenses. And they said that, I'm sorry, that was a Peacock case. But in the Regency case, there was the breach of contract, negligence, fraud, and they said that was all intertwined. And the defendant contractor's claim for breach of contract, quantum merit, and foreclosure of construction lien were all intertwined services. And the homeowner in that case who beat the contractor was entitled to get full attorney's fees. And that's what Judge Huey basically said, that the cases were not intertwined. That's more than a fact, that's a legal finding of what we got here. And disagreeing with Mr. Amity said, the lien amount, he says, was constantly agreed to. I put a chart in my reply brief of all the different back and forths that went where there was, the amounts were never agreed to. And remind the courts that they contested the validity of the lien from day one. They claimed that there was, first it was, you couldn't do a lien because it was arbitration, then it was because it was fraudulent. And then because basically the amounts were not due. These offers from filing of the lawsuit until the end of the case have been zero. So if you have an agreement of the lien amount, you say so, you stipulate, we will agree to that. They never agreed to any lien amount. Mr. Amity was given the opportunity to provide sworn testimony at the same hearing that I testified to, and he declined. It was only argument. So there was never an agreement, and Justice Smith, you kind of hit the nail on the head. The judge asked if he would stipulate, and he would not, as to what the lien amount was or the amount that was due. Now, I'll take 2 minutes. The original contract
You
provided.
only have 45 seconds.
Okay, the original contract provided for conventional trusses, so that you look like at a hunting lodge and everything is finished when you look up. They made it smaller and put mechanical or engineered trusses, which see all the gussets in the metal, and he didn't like it. So after that was up, that's when he decided he wanted the ceiling. It was put up and they were working, and then he said, I'm not going to pay for it because you did not get a change order in advance, and that was a big, huge dispute. So I believe that the court first should overrule, and second, the lower courts have no guidance on how to hold these hearings. And if you give an opinion here with guidance of what the court should consider or should not, it would be greatly helpful. Tritech just doesn't apply in this case.
Thank you both very much. Have a good day. Our next case,